Hello, everyone. This is Annie Cartwright, an attorney in Husch Blackwell's Education Group. We're excited to offer today's presentation on minimizing the risk of employment litigation against your college or university under state and federal civil rights laws. Before we start, I'll cover a few housekeeping items. At the bottom of your audience console are multiple application icons for you to use during the program today. If you have any questions during the webcast, please submit them via the question box icon. We'll try to answer all questions today as we have time, and if we don't, we will do our best to answer them later via email. We really do appreciate your questions and audience interaction, so please feel free to submit anything that comes to mind. There's also an icon to assist with your viewing preferences. Please note that you can expand your slide area by clicking on the maximize icon at the top right of the slide area or by dragging the bottom right corner of the slide area. If you have any technical difficulty, please click on the help icon. It bears a question mark and provides information about common technical issues. Finally, a copy of today's slide deck and additional materials are available in the resource list icon that looks like a folder at the bottom of your screen. This program has been approved for Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin continuing legal education credit. To report your hours in Illinois, Kansas, Nebraska, Tennessee, or Texas, click on the CLE widget at the bottom of your screen and complete the questions. You'll need your bar numbers to submit those. Please make sure to do this before the webcast concludes. A recording of the webcast will be available tomorrow for watching and sharing. Once it's up, a link to the recording will be emailed to you along with a certificate of attendance. Joining me today are Michael Raup and Tim Hilton. Michael assists clients with complex litigation, high-stakes regulatory disputes, and appellate proceedings. He regularly advises businesses and education clients on constitutional, statutory, and procedural issues. Tim focuses his practice on defending employers against employee lawsuits and counseling them on best practices to avoid potential liabilities. He also focuses on employment-based immigration compliance, specifically related to Form I-9 and E-Verify. Both are among our team members who are former federal law clerks, and we turn to them for help when we're looking to unpack the meaning of complex and sometimes challenging case law, especially in the area of employment. With that, I will turn the webcast over to Tim and Michael.
Thanks very much, Annie, and I too appreciate all of you taking the time to join us today. Just a brief agenda for you before we get to some of the tips that we've got for minimizing litigation risk. We're going to take some time to talk about sort of the background law that goes into these employment cases and some of the background topics that are important to understand in terms of minimizing that overall risk. So we'll start off talking a little bit about an overview of the employment relationship and the different forms that that can take. And at the outset, as the note on that slide indicates, these topics don't include tenure issues. So if you have issues that are related to professor tenure, anything that could apply to your tenure policy, it's critical, of course, that you follow the terms of that tenure policy. So these are the balance of this presentation is going to be focused on the other types of employment relationships that exist at your institutions. So the default form of employment is what's known as at-will employment. And as the slide indicates, this is the default status in most states. So anytime you hire an employee, if they're not subject to some sort of contract or agreement, if you just hire someone to take a position, the default is that they're an at-will employee. And the effect of that is that you can fire that person, demote that person, for any reason whatsoever, as long as it's not specifically foreclosed by a law. And there's no expectation of ongoing employment, so for any reason, that employment relationship can be ended by either the employer or the employee. There's no need to show good cause, fair cause, anything. It can be on a whim at the leisure of the employer. Now, there are certain ways that this employment relationship can be altered, and the most common, of course, is a contractual employee. And so in essence what this means is that you've entered an agreement with the employee, and that agreement has altered the terms of that at-will employment. Most commonly, you'll see terms requiring some sort of cause. There has to be due cause, or some sort of cause needs to be shown to fire an employee, demote an employee, that sort of a thing. And all of that is going to be governed by the specific terms of that contract. Usually they're going to be for a fixed period of time, but of course that can be and commonly is extended. Terms can be changed throughout that contractual relationship, and again, it's all going to be by the terms of that exact arrangement. We did have one note on here about arbitration, and because a lot of this, the balance of this presentation is going to be about minimizing litigation risk, we did want to make sure and throw the concept out there that you can require employees to arbitrate disputes, and occasionally those could defer some sort of litigation and deter some types of litigation. But it's important to look at your specific state law as it relates to arbitration agreements and the enforceability of arbitration agreements, because those terms are going to be governed exclusively, well, in most cases, by state law, and the enforceability of them is going to be governed by state law principles. So important to look at that issue on a state-by-state basis. We'll have a few poll questions throughout the presentation today, and this is the first one. It's a true-false question, and the statement is, only those employees with a signed agreement can claim to be, quote, contractual employees. So if you please take a moment to answer true or false. We'll give a few moments for people to respond.
We've got a smart group, Michael.
It looks like it. All right, and it looks like most of you have selected false, and that is the correct answer because there's a concept known as implied contracts. This is going to occur in a circumstance where there is not an actual agreement between the parties. There's not a tangible piece of paper that you've signed with the other side, with the employee, but the employee is going to argue that certain things you've said or certain things you've done or certain policies and the way that you have enforced them have created an implied contract between the employer and the employee. Now, we see these most commonly where there are poorly drafted provisions either in some sort of school policy or in employee handbooks. And so Tim will talk more later in the presentation about ways to avoid this, but just beware of this. And flag this as an issue to potentially follow up on, making sure that your that your policies and handbooks don't unintentionally create obligations for the employees or expectations for the employees where they could assume that they are part of a contractual relationship with you if you do intend them to be true at-will employees. So now I'll turn it over to Tim to talk briefly about some of the causes of action that we can see arising out of these employment relationships.
Thanks, Michael. This is Tim Hilton, and I'm going to talk for a few moments about the types of causes of action that we typically see, so you don't end up facing down some mean lawyer or employee like the person in the slide. I spend a pretty significant majority of my time on the day-to-day of litigation, but also some day-to-day counseling in terms of avoiding that type of litigation. So Michael spoke briefly about contractual employee, and so when you have a contractual employee, oftentimes the cause of action that will result is a breach of contract. So, as Michael sort of discussed, the two basic types of employees you're going to have are at-will employees and contractual employees. These are breach of contract claims are probably, a pretty small percentage of the types of employment lawsuits that get filed. For reasons I'll discuss in a moment, they often will result or have lower amounts of damages that are available, but this is certainly not a a thing to be ignored. I've litigated $1 million breach of contract employee cases for physicians, and the damages can add up even though you're not talking about the types of tort claims that you get under the civil rights laws. The damages are often going to be limited to what lawyers would refer to as the benefit of the bargain. The parties entered a contract, and in that contract they agreed upon what the expectations would be if the employer is alleged to have breached the contract, for example, by terminating the employee early. The employee's primary source of damages would be the remainder of the contract. There's going to be expectations and requirements for the employee to mitigate his or her damages under the contract, hopefully by obtaining further employment. That can further reduce the lost wages damages that are available. Unlike the civil rights laws that I'll talk about in a moment, these are not the types of claims in which you're going to see punitive damages being available, or non-economic damages such as emotional distress or things like that. Oftentimes, there will be no attorney's fees that are available. Unlike the typical rule in American law is that in a lawsuit, each side will pay for its own attorney's fees unless there is a statute or a contract to the contrary. When we talk about the civil rights laws, I think almost 100% of those provide for prevailing plaintiff attorney's fees, which certainly can add up into the hundreds of thousands if you litigate the case through trial. In the abstract, a breach of contract claim does not have attorney's fees available, but of course the parties can have agreed in the employment contract to have that in any litigation that comes from this contract, that the winner will pay the other side's attorney's fees. And another important point that's a benefit for the employers is that you're not going to have individual liability that are available on these sorts of claims, unlike what you sometimes have under the civil rights laws that we'll talk about in a moment. The other main type of employment claims that we deal with are what you would regard as discrimination claims. The federal government and pretty much all the states and some municipalities have civil rights laws governing anti-discrimination, anti-harassment, anti-retaliation, which of course covers people if they have made a complaint under any of these laws, even if it turns out to not be a valid complaint, that you can't take action against the person for making that complaint. These are remedial statutes that have been passed by Congress and the state legislatures to make an employee whole for the damage that is allegedly inflicted upon them by some unlawful employment action on the basis of race or gender or religion or disability. To that end, it does not just allow for the types of contract damages that are available. You will get emotional distress damages often. You will get allegations of punitive damages which are damages that are designed to punish the defendant even when the plaintiff may not have the actual damages to support that. And they almost all allow for the recovery of the plaintiff's attorney's fees. So even in a case where you have, say, a relatively low-earning employee, that employee will, and say that employee is later reemployed at the same or a higher rate, such that it almost eliminates their lost wages damages. They will often be able to prove up some sort of emotional distress damages, which will be up to the jury to decide what that is worth. If the jury is sufficiently outraged by the alleged conduct of the employer, the jury may find punitive damages against the employer, and almost always a prevailing plaintiff will be awarded his or her reasonable attorney's fees, after which the plaintiff's attorney, who will almost certainly work on a contingency, will get to submit a year or so of his or her hourly bills, and the losing employer will have to pay those. And these will also often include claims against individual supervisors, which is a very unfortunate tactic that many of the plaintiffs' employment lawyers out there use, both to embarrass and harass individual supervisors, and it can also be an important legal tactic to pick the forum in which they want to litigate the case by having an individual supervisor who's located in one state and say if the employer is located in another. All right, we have another poll question here. And just from your perception, we'd like to get your thoughts on what type of civil rights claim has your institution most commonly experienced. We'll give you a few moments to respond to that.
And this isn't one where we can get it wrong.
Yes. Well, they're all wrong, but... Okay. Thanks very much. Looks like we have, kind of what I would expect. You see a lot of race claims. You see a lot of gender or sex claims, and then a smaller percentage of disability and age claims. It's interesting. We didn't put retaliation on here because almost every case I litigate has some form of retaliation alleged in it. And that's actually, in my mind, the most dangerous claim because it's the most easy for a jury to understand, and it's simply natural that if you make a complaint against someone, even if that complaint is not validated, that you then later a jury might understand how later action taken against the complaining party might seem like retaliation. Unfortunately, I think, and we'll talk a little bit in a moment about the different statutes, I think that in terms of the actual substantive issues that are out there, I think you're going to find that in reality there's more disability and age discrimination than there is race and sex discrimination. But it doesn't look like the numbers have shaken out that way in terms of the claims that you all have experienced. And so talk very briefly about what are the civil rights laws out there. Excuse me. Title VII of the Civil Rights Act is the federal law that provides for most of the anti-discrimination, anti-harassment, anti-retaliation rules that we have. Down at the bottom, as I mentioned, states and municipalities have almost all have their own corollaries to that, some of which are going to have, different levels of protection and certainly different evidentiary standards of what has to be proved. The ADA is a unique one. I'm sure everyone's familiar with the ADA in terms of providing, anti-discrimination for persons with disabilities. The ADA is unique in that it is one of the only statutes that, we all understand the negative requirements of not taking race or gender or religion into account. Obviously, the same is true under the ADA, but it also puts affirmative obligations on the employer to provide reasonable accommodations for disabilities. The ADEA is Age Discrimination and Employment Act. The OWBPA, we'll talk about both of those towards the end when we get into severance agreements. Family and Medical Leave Act is another one, which in addition to having anti-discrimination and anti-retaliation rules, if you are of a certain employer size and certain employees are entitled to the affirmative rights of, unpaid job-protected leave. The Rehab Act is basically the way that these rules are applied to federal agencies and institutions that receive federal funds. Workers' compensation is its own sort of animal under state law. And in addition to the substantive rules that deal with how to handle employee injuries, there are almost always anti-retaliation workers' compensation rules. That Michael's going to talk a little bit about the standards by which some of these are proved.
Thanks, Tim. And we'll try not to get too far into the weeds into how the law actually works in these circumstances. But Tim and I thought it was important to give you a little bit of information about how a court is actually going to evaluate these cases, what type of evidence they are going to be looking at. Because when we start providing you with tips and strategies for avoiding or potentially prevailing in employment claims, it's important to know what kind of evidence your lawyers are going to be coming to you and saying, we need to show X, Y, or Z, and here is the documentation, or here are the type of things that you can have to be prepared for this type of situation. So there really are two types of, when we're talking about discrimination cases, there are two types of cases. First is on the slide in front of you, and those are the direct evidence claims. These are much more infrequent than the indirect claims that we'll talk about in a moment. And here there is actual direct evidence that the employer used an improper basis or a discriminatory basis for making the employment decision that they did. And you see that term there, a quote, adverse employment action. And that's the term that is thrown around in the law a lot. For purposes of this presentation, think firing, but it can be anything from firing to demoting to decreasing pay. There can be all sorts of things, but for purposes of this, just think firing. And so in other words, there's direct evidence that the employer used an improper basis to fire an employee. So these would be things like notes in the file or email communications or recorded conversations or something that says, we fired X employee because they were too old for the position. Things that show a direct discriminatory motive. And yeah, Tim?
Yeah, I just wanted to jump in real quickly. Sorry for the interruption, but a direct evidence case can come up. Of course, it doesn't have to be admitted that this took place. I litigated a case where there was an allegation of an overheard statement of, well, the problem is that she got pregnant too fast. And of course, the individual who was alleged to have said that denied having ever made that statement or feeling that way. But direct evidence does not have to be something that's proved. It's an allegation.
It's an allegation, yes, and that's a good point. And so what we're looking for in those circumstances, of course, then would be things that refute that was the actual motive. But again, the much more common type of case that we will see are the indirect evidence claims. And again, this is where it's supported by circumstantial evidence or evidence surrounding the employee termination. And so we've listed a few examples there of things that could show indirect discrimination or an indirect improper basis for the employer making the decision. And so, and the point here is that not any specific piece of evidence is going to prove that there was a discriminatory intent or an improper basis for taking the employment action. It's all of the circumstances as a whole make it more likely than not that the basis was improper for this claim. And so these are the more common types of claims, and so you're going to see that there's commonly evidence on both sides. And so the question then becomes, how do we resolve these? How is the court going to look at evidence on each side and determine how this occurs? And at least in federal court, this is done through a framework called the McDonnell-Douglas test. And the reason it's called that, it comes from a Supreme Court case in 1973, McDonnell-Douglas versus Green. That's the only reason that it's called that, but you'll hear it referred to this a lot in the legal realm anyway. And so we wanted you to be familiar with that term. And this occurs at and you see this on your slide too, this occurs at the summary judgment phase of the litigation. So this is after we have all of the typically after we have all the documentation, we have all of the emails, everybody's reviewed everything, potentially taken depositions of the employee and of the supervisors that were involved in the firing decision. And after all of that evidence is in, the question then becomes, how does a court evaluate it to decide whether or not this case should move forward and go to trial? And the best way to think of this stage of the litigation is as a tennis match. And so the plaintiff has to show something, and then the burden shifts to the employer to show something. And then if they're successful in doing that, then it shifts back to the employee to show something again. And so you see here how that plays out. The plaintiff has to start by showing their prima facie case. Then the burden shifts to the employer, the institution, to show that they had a legitimate reason for taking the case or for making the decision that they did. Then the burden will shift back to the employee if they believe that even though that evidence is there, they can show that it was pretext, that there was that even though there's some evidence showing that there was maybe poor performance or whatever, the employer's real reason for doing this was discriminatory in nature. And so that's kind of how it plays back and forth. And we'll give you a few specific examples here of what this looks like. So the first step, again, requires the plaintiff or the employee to show their prima facie case. All that prima facie case means is that they have to show the elements of what they're claiming. And you see the four of them listed out there, being a member of a protected class, qualified for the position, they suffered that adverse employment action, and then the final one, can sometimes present issues, whether a similarly situated person that's not in that protected class was treated differently under similar circumstances. Now, of course, that one is commonly litigated between parties, whether the other employee is truly similarly situated. Were they in a job role that was similar? Did they have similar performance throughout their tenure there? So that one can be commonly litigated. But again, at this stage, it's just going to be the burden on the plaintiff to show these things, and then the institution is going to have the ability to rebut that. And that's what we get to next, which is the legitimate, non-discriminatory, end quote, reason for the employment action. And so what this means is that the employer is then going to have the opportunity, and not just the opportunity, but the burden to demonstrate that even though the employee has shown that they can meet their prima facie case, there was a legitimate and justifiable reason to fire this employee. Their performance was poor. There are documented legitimate bases for the decision being made. And this is where we'll get to, as the presentation continues, how important it is that things are documented throughout the employee's career to demonstrate the basis for an eventual employment decision should that become necessary. So after that, we then switch back to the plaintiff. And the plaintiff can then attempt to show that even though there's those legitimate reasons, even though there was poor performance, even though there were unexcused absences, that sort of thing, that doesn't matter because the real reason that the employer decided to fire me was for a discriminatory reason. And so the burden will shift back to them, and it's then the employee's burden to put forth evidence demonstrating that that is the case. And some common we'll list a few common forms of this here because this can give you some ideas as to things to avoid in documentation, and also, these are not obviously appropriate things to consider when making the determination. Giving different reasons, other people not being treated the same, a delay, deviation from policies is a big one, and we'll talk more about that. But it's not just how you have your policies drafted. That is important, but it's also that those are then applied consistently and applied according to their terms. And so these are just some examples of things that employees will typically try to show pretext. So again, I apologize that we got a little ways into the weeds on how these cases play back and forth, but I think it's important to have that base level of understanding on how us lawyers litigate these cases and the types of evidence that we need to defeat these claims so that you know what's necessary in terms of how you evaluate claims and also how you are keeping your policies and your records as you're making employment decisions. And so with some of that out of the way, we'll turn it back over to Tim to start to talk about some of the tips for minimizing risk.
Thanks, Michael. Yeah, and I just wanted to follow up on Michael's end there at the end. It's always the plaintiff is the person filing the lawsuit, but ultimately they have the burden of proof when you get in front of a jury. It's always the plaintiff's burden of proof. But if we want to avoid the risk of going to trial and the expense of going to trial, it's our burden to win at summary judgment. And in order to do that, you often will have to follow the framework that Michael outlined. Summary judgment is not required, and if it's something that we just choose to take to trial, then it's going to be the plaintiff's burden. But it's always going to be preferable, if it's at all possible, of course, to get the case dismissed before you get to that point.
And one other point I wanted to mention, and that's exactly right. One other point, Tim, I wanted to mention too is that there are state corollaries, as Tim mentioned, to these discrimination laws, and your state may be different as to how these cases are evaluated at summary judgment and the type of evidence that is necessary. For our friends that are joining us from the state of Missouri, this is obviously a hotly debated topic during this session of the legislature as to whether to adopt this type of McDonnell-Douglas framework for state discrimination claims. So that framework we went through applies in all of your federal litigation, and then in some 30-something states that will apply, but it can differ based on your state.
Yeah, absolutely. And it's good that Michael mentioned the importance of policies. Because the first tip that I'm going to talk about in terms of minimizing or avoiding the risk of employment litigation is having clear policies and expectations. There are not that many policies that I would treat as quote unquote mandatory in terms of we have to have this or we're in big trouble, or the government is going to come after us from a compliance perspective if we don't have this policy. But there are many, many types of policies that are very important to have. And a lot of employers, unfortunately, look at a policy or a handbook as a one-time thing that you issue it and then you put on the shelf, and you assume that it's everybody's following the same rules that HR and management expect them to follow. And there's really no way to avoid that other than sort of a long-term effort of building a culture of compliance and a culture of treating the handbook and the policies that we have very seriously and applying them very seriously. This isn't covered here, but I'll see a lot of policies that talk about state things in really strong terms and have what seem to be very harsh and very strict rules, and that's fine, assuming that the substance of what you're trying to do is lawful. Having strict policies is great as long as you're enforcing them. If you're not enforcing them, they're actively harmful because, as Michael mentioned, even if it's not a McDonnell-Douglas issue, I can tell you from sitting in depositions, the lines of questioning that are keyed in on, well, you didn't even follow your own policy here. That is a very deadly line of questions because it looks terrible to a jury in terms of, well, you had these policies and you went off and did X, Y, Z anyway. So on the slide, we talk about policies are important to set forth clear expectations. It's really important to have periodic review and updating. Obviously, the law changes, and counsel can advise you on changes in the law that you need to update your policies for. But you may have written a policy thinking that the workplace would be a certain way, and even if the law hasn't changed, the circumstances on the ground may have changed, and there's no problem with revising your policies to sort of meet the expectations of the way it's really played out. You don't want to continue with, for example, a policy that says you have to call in 2 hours ahead of time. If no one's really been following that rule and all the managers don't think that rule is necessary, you might as well revise to take that out so that people aren't confused. And finally, of course, when a situation arises that isn't covered by policy, you're not necessarily prevented from addressing it, but please be aware that, of course, creating or having the perception of creating a rule after the fact can have problems. We just briefly talk about a lot of the missing policies that we see. And again, it doesn't necessarily prevent you from having or treating a situation a certain way, but when you don't have a policy, it can be problematic. Consensual relationships between students and employees, use of institutional resources for personal gain. Obviously, you don't have to have a policy that says no stealing, but if there's a question in terms of using a fringe benefit for personal reasons, If you don't have that spelled out that you can't do it, even if it doesn't add up to stealing, that can be problematic. Conviction of crimes that damage the employer's reputation. I can tell you that agencies like the Equal Employment Opportunity Commission are starting to look very seriously at how employers treat criminal records and certainly arrests. And I can tell you, if you want to be able to take action against somebody as a result of a conviction that they have, it's important to have that down on paper. Maintenance of student confidentiality is obviously something that I'm sure you're all very sensitive to with respect to FERPA, but there can be wrinkles to this in terms of the interplay between when you have a student who's a student and a student who's an employee. And of course, the law sets the floor, not the ceiling in terms of confidentiality. And it's good to have policies in place that spell out what we are going to do, even if it's simply to comply with the law. The last two, weapons in the workplace, this is a really hot topic. As I'm sure you know, many states are pushing for the availability on public property of people to open carry or concealed carry weapons. This is a very state-by-state issue, and you need to be aware of what the rules in your state are and create a policy that meets what your expectations, the result you want to achieve. And personal use of the internet, personal use of technology resources is also somewhat of a state-by-state issue. But if you don't have it spelled out, it can create problems. For instance, if people have a reasonable expectation of privacy in their email that isn't discounted by an express policy that says you don't have that expectation of privacy, then they may be able to, send privileged communications to their own attorney who is suing the institution, and there's nothing you can do about it. Our next poll question is just a true-false, and we just kind of want to gauge, because I'm going to talk shortly about documenting concerns. My institution has a program for training managers on how to document performance concerns.
And while we're waiting for the answer to this one, I'll throw in a note on the last slide about policies on institutional use of resources. We see a number of times an institution may have a challenging employee and may not have documented past non-performance or past misconduct, and then everything comes to a head and the institution is ready to terminate the employee and will often turn to a use of institutional resources for private purposes policy. But the challenge there can be that the institution hasn't enforced it evenly in the past, and where you're singling out one employee for application of a policy and you haven't applied it to others in the past. I will confess to having used institutional resources now and then to surf the internet or something like that, as I think most of us have. You're really inviting some challenges to your decision making.
Yeah, that's something that it might sound great to say we have zero tolerance for use of institutional resources for personal gain, but in some of the ways Annie's just highlighted, that's not a policy that can realistically be enforced. And when you turn around and try to use it against somebody, then you may run into problems when you haven't done that all along. So we're going to talk, as I mentioned briefly, about the importance of documenting performance concerns. And so this, I think, is a training topic that could be obviously addressed based on the results here. And we'll talk a little bit in a moment about why it's so important to have good documentation in place. And effective manager training is a great way to minimize or reduce the risk of employment litigation. You want to have documenting and confronting performance issues. That might sound simple, but this is unfortunately something that HR and high-level management are not going to be involved in. Michael's going to talk about this in a moment, but you have to have frontline manager buy-in in terms of good documentation and in terms of consistently addressing behavioral and performance concerns. You just have to have that because they're the people who are going to be filling out the performance reviews. They're the people who are going to be deciding on when and where to give formal or informal documented performance guidance. And if you've got some people that are just letting everything slide, and some people that are really nitpicking everyone, then if, that's creating disparities between employees, and we don't want to have that. Basic awareness of civil rights laws is important, especially, the ADA and FMLA and work comp. Basically the rules, the areas that I highlighted earlier where the employer and managers are under affirmative obligations are really important to have training on. Everybody understands that I can't discriminate on the basis of race, that I can't discriminate on the basis of gender. And when those types of claims are made, it's just typically going to follow the pretext standard, and it's going to be a credibility test between two people of whether or not the jury believes that you took race or something like that into account. But where you have affirmative obligations, for instance, if an employee is talking about their medical condition and talking about how their medical condition affects their performance, that's putting the manager, and by virtue of the manager's position, it's putting the institution on notice that this person is in potential need of a reasonable accommodation to perform their duties. And if you don't have a manager who's trained to identify those things, that's going to be a problem. And you'll find that at the time when the manager hears that, it may not be a big issue. But a year later, when the employee is terminated or given a poor review, you may find out, well, I've been telling my manager for a year that my fibromyalgia is causing me these problems, and no accommodation was offered. There's no requirement that the employee come to you and say, I hereby request a reasonable accommodation. Basically, the idea is you want to consider what your answer is going to be when you sit in a deposition and you ask, when was the last time you were trained on how to evaluate reasonable accommodations under the ADA? And if the manager or certainly the HR rep's answer is I don't know, or we haven't been, even if you don't feel anything unlawful was done, that looks bad. A few quick manager pitfalls, providing variances from the rules, excusing unauthorized leave, that can create, formal and informal expectations of what's going to happen in the future. Unilaterally granting disability accommodations. Reasonable accommodation is a very individualized, circumstantial process. And, we've had situations where the manager, it comes out that the manager has been providing such and such lifting restriction for a year. And when HR learns of it, HR says, well, hold on, we can't do that. We haven't done that in other situations. And that creates a big problem when a manager has done it, because their actions bind the institution. A lack of understanding of when a absence can be held against an employee may result in punishing or demoting employees for what was authorized leave that you can't take action based on under the FMLA or the ADA. Failing to follow restrictions for work comp, this is a big one. Obviously, we don't want anybody to get hurt. The employee often wants to work and may say, well, my doctor says I have this, but don't worry about it. And that's not something that a manager should ever fall for, because it's going to create the expectation, and then of course if something happens to the employee that causes them to get hurt, it's going to create an even bigger set of problems. And the last two sort of go together: giving good reviews to bad employees. I hate to say it, but you really want to resist the urge to be nice. Ultimately, our relationships with our employees are not personal; they're professional, and your managers aren't serving the institution, and they aren't serving the employees' interests if they are just letting them slide and giving them a good review to be nice. And the same goes in terms of failure to document violations and performance issues, because if you don't have that documented later, when the manager tries to testify at their deposition, well, I talked to Bill about that 5 or 10 times, and Bill says, no, you didn't. Well, the plaintiff's attorney is going to ask, well, where's the documentation of that? Where's the note? Even if it's not something that the employee has to sign, it's important to have contemporaneous documentation of performance issues. And with that, Michael's going to talk a little bit about responding to grievances.
And Tim talked a little bit about this, about affirmative duties, and that's what's really key to be aware of when an employee comes to any type of a manager with a grievance or complaint or raises an issue, is what affirmative duty has been placed on the employer to respond. And that, of course, depends on the type of grievance and on the different types of discrimination laws. But, of course, things like Tim mentioned, the reasonable accommodation to a disability. If there's any sort of a complaint of harassment, it is going to trigger duties to investigate and potential remedial action. And so it's important that the managers be sufficiently trained to identify those issues, or whoever is ultimately referred these type of grievances. Of course, it's also important for employee morale. Employees want to be confident that their employer is taking seriously complaints of any type of harassment or discrimination and is doing what is necessary to remedy those situations. Documentation in this realm is essential because it's important to show that pattern in practice of the employer should anything ultimately result in documentation. Thoroughness and objectivity. Objectivity is one that it's easy to say now. Of course we're going to be objective about it, and we're just going to evaluate, and we're going to investigate, and we're going to do it in a straightforward manner without bias on either side. But that means more than just evaluating the claim, and a good example of this is that you want to keep the investigation of a specific grievance sealed from any other issues that arise with that employee. Too frequently there are instances where an employee will come with a grievance. You'll sit down with that employee to begin the investigation and talk to them about what happened, what the issue is that they want to raise, and so that will be all documented. You'll be taking good notes on what's going on, and then the conversation will be, well, while I've got you here, we also wanted to talk about these performance issues that we've been seeing in your performance. And the problem, of course, with that is that later on down the line, if this gets to litigation, at the same time you were honestly trying to address their concerns, you were also making a record for a future employment action that you could take against them. And so those lines, and of course that employee's attorney at that time is going to try to bleed the lines between the two and say, well, if they wouldn't have made this complaint, you never would have brought this issue up with them. And that's the type of thing you want to avoid. So it's critical that when an employee complaint or grievance comes in, that be isolated from any issues with the employee. I want to talk in a little bit more detail now about some of the documentation of some of these performance concerns, and we'll start with our final poll question of the day, anonymous, of course, which is performance reviews or ratings at my institution are inflated beyond what they actually should be by, not at all, 15%, 25%, or 50% or more. And so if you please submit your answers, that'd be great. All right, so there are the results we come up with, and it looks like certainly a plurality saying about 25%, and then a large majority saying by at least 25%. So this is a common problem, and it's a cultural problem through grading and everything we have, I think. So that's some of what goes into this. But a lot of this concern goes back to what Tim was talking about earlier, about how it doesn't, down the line, it doesn't pay to necessarily be seen as quote-unquote being nice or being, being quote-unquote supportive of employees in documenting employee performance concerns. Tim talked a minute about frontline manager buy-in being crucial. And that's so true in this realm because it's not going to be HR professionals all the time that are doing employee evaluations. Frequently, it's going to be folks that are much more versed in the subject matter of what that employee is doing, not necessarily in the HR component of it. So training is critical to making sure that they understand what the policy of the university is and what tactic the HR department is going to take. And, simply put, give people what they deserve. It's not, you shouldn't be worse, shouldn't be better. Honestly give them what they deserve. Now, of course, the perception gap is huge here because, again, going back to the if I didn't get an A, then it's not satisfactory, look at what the labels are that are given to the performance scores that you utilize at your institution. If you say we have high expectations at the institution and the employee gets a rating that says meets expectations, that should be perceived as a good thing at your institution. But if the culture there is such that unless somebody gets exceptional or far surpasses expectations, that is seen as underperforming, that's where that perception gap and a problem comes in. And it's important that this consistency carry through, and that's what we're looking for in defending these type of claims. And then to consider the specific issues that are referenced in that specific question. So, be careful in these issues if you're raising things that could later be shown to demonstrate discriminatory intent, such as if you have something in a performance review that says they took leave and that really upset me. Well, if that leave was required by FMLA or whatever it is, you could be setting yourself up for a potential problem. So again, this all goes back to training the folks that are going to be implementing these evaluations so that they are aware of these concerns and know how to adequately document them. With that, I'll turn it over to Tim to provide a few more tips for us before we conclude here.
Sure, thanks. And we're hitting the home stretch, so if you want to go ahead and submit questions, we'll try to address them at the end or follow up with them. We just had a real quick one asking about the perception gap. That's kind of what Michael mentioned in terms of, and I'll just give a real quick example. I had a case in which there was a new manager, and he was a former military intelligence guy. And the idea was, he was obviously a little bit more no-nonsense, and he was giving people, meets expectations. And the idea was, yeah, we have high expectations, and you're meeting them. That's a good review. But the culture that had been created before he got there was that everybody gets 4s and 5s. And I can tell you this manager was just shocked to be dealing with all these employees in tears after he gave them what he thought was a good review. So that's kind of what we mean when we talk about the perception gap. And that's why it's important to try to be have training on evaluations, training on documentation, to try to make it as consistent throughout the institution as possible. I'm going to talk a little bit real quickly about timing. Timing is very important, especially for retaliation claims. You're always going to have an employee who looks at something and say, well, that seems a little odd, so the timing must be important. Anytime you vary from your normal processes or schedules, if you all of a sudden give somebody a review out of the blue, that's a big red flag. Obviously, if somebody has just come back from a leave, a protected leave, has just given notice of a disability, has something like that, that's a protected activity or joining a protected status, and we start taking action against them after that, it may be reasonable, but just be aware of the perception of that. One real quick thing that I wanted to note is that employees are always keeping track of what's going on with the institution, and so there can be morale problems if we start if we have a layoff after we've just announced something, some big donation or something like that. And there's nothing we can necessarily do because the employee, that may not have anything to do with the employee's performance, but it's just something to be aware of. If the institution has just hired some big important professor from across the country and then somebody else gets laid off, just be aware of the effect that can have on morale. Electronic departure protocol, I'll discuss very quickly. This is very generally, could be its own topic, but procedure for securing electronic information after somebody leaves. You should be aware, obviously, of disgruntled employees seeking to steal or destroy data. That's why it's important to just have a process for this set up. Also, this sort of information can be important for future litigation. You may discover, as I'll talk about briefly, something that can give you a defense. And any time, and we're going to have Husch Blackwell is going to offer a program on legal hold later this summer. But any time you're put on notice of the likelihood or a threat of future litigation, again, you're under very specific rules and very important rules to follow of how you preserve data that may be relevant to that. In these employment claims, the employer has all the data. Discovery is skewed hugely in favor of the employee, because once they leave, they don't have the documents, they don't have the emails, they don't own the policies. So we have access to all the data, and we're going to be under a higher obligation to preserve it. After acquired evidence is a defense that often comes up that the electronic departure protocol may be something that we're able to preserve. Basically, if we discover something that we didn't know after the employee is terminated that we would have terminated them for, this can be a defense that either reduces damages or completely wins the case. Examples of this may be if we discover that they've made false statements on their application, that they've been falsifying their time cards, or making some other sort of violation of policy. Again, it has to be something that we didn't know about, we being the institution and its managers, and something that if we did know about, we would have taken severe action against, almost, and it pretty much has to be termination. The most important, want to talk more time talking about severance agreements. These are a critical tool to really eliminate liability in any case where there's a risk of employment litigation. And obviously, I'm sure you all understand what a severance agreement is. The employee is paid or given something of value in exchange for a release of claims. Oftentimes people say, well, we're firing this person. We have a good reason for firing them. Why are we paying them off? And the reason is, if we think there's a risk of litigation or there's been a threat of litigation, there's a finite amount of money that you're going to spend. You can spend it on litigation, or you can spend it early on to get some finality and completely eliminate the risk of litigation. So in severance agreements, often there's a monetary payment. There's some sort of continued benefit. There can be non-monetary things in terms of confidentiality, providing the employee with a positive reference or a neutral reference that we wouldn't otherwise do. Or even I've had cases where it turned on physically altering, their termination from from a firing to a resignation to allow them to truthfully represent in the future that they haven't been fired. The employee will obviously waive claims. They may agree to resign as part of it. We often require a non-disparagement clause and even a no rehire, no reapply clause, which is an agreement that they're never going to apply again. Some of the pitfalls and problems that we'll have with severance agreements, if you're getting a waiver of an age claim under federal law with ADEA and OWBPA, that's the Older Workers Benefit Protection Act, there are certain rules that you have to get a waiver of an age claim from a person over 40. You have to give them 21 days to consider the offer, and then they have 7 days to revoke it. Otherwise, that's not a valid waiver of an age claim. And in a situation where you're doing a group layoff or some sort of reduction in force, there are even more specific rules. It's important to get a release that covers any and all claims arising out of the employment relationship, and to make clear that that applies to individuals, because for insurance purposes, if you get a waiver only against the institution and they turn around and sue their manager, that's probably going to result in your insurance carrier having to cover that claim. There are tax issues that arise in severance agreements with respect to whether things are characterized as wages or not. If a person is making a wage claim, you pretty much have to apply a significant portion of it to wages. Be careful not to be overbroad in terms of attempting to waive future claims that haven't happened yet, or attempting to limit the employee in their ability to talk to the EEOC or cooperate in a future EEOC investigation. Those are invalid provisions, and oftentimes it could result in the entire waiver being rendered invalid. And you might be able to get the money back, but the person's still going to be able to sue you. And finally, as we talked about, confidentiality and non-disparagement are two-way streets, and you want to be careful in terms of what you're agreeing to, in terms of what is said to other employees about the reason for termination and things like that. So we're a little bit over. I think we have one question.
And I think it's going to be a pretty quick one, Tim.
Yeah.
You commented on this briefly, and if you could just answer quickly, does an employee have to formally ask for an accommodation, or if they say, my duties are flaring up arthritis or some other condition, is that sufficient to put the employer on notice?
Yeah, that's going to be circumstance specific, but I would say that is probably sufficient to put the employer on notice. And the policy reason for this is a good one. Employees aren't necessarily going to know about the ADA or what their rights under the ADA are.
Right.
And that there's no requirement that an employee know that they're entitled to an accommodation. But if you as the manager and as a result the institution are aware of a potential need for one, then you need to institute some sort of a dialogue about an accommodation. And it may be that there's not one that can be provided, but that has to be an individualized process that's looked at.
And you mentioned training programs for managers. As managers are trained to recognize these situations, they will be more able to deal with them, certainly.
Yes.
Well, thank you, audience, for joining us, and thank you to Michael and Tim for sharing your expertise with us today. We hope the information we provided was helpful to you and to your organization. If you haven't already, please click on the survey icon at the bottom of your screen to complete our short survey. Your feedback really does help us develop quality and meaningful programs in the future. As a reminder, this program has been approved for CLE, continuing legal education, in Colorado, Illinois, Iowa, Kansas, Missouri, Nebraska, Tennessee, Texas, and Wisconsin. A recording of the webcast will be available to you tomorrow for watching and sharing. Once it's available, a link recording will be emailed to you along with a certificate of attendance, and the link will be active for approximately 2 weeks. Please be sure to join us for our next webinar on June 14th on accommodating pregnant and parenting students. This concludes our webinar. Thank you.